Welcome to the 11th lecture in this lecture series on international arbitration practice. In the last few lectures, we have been discussing about drafting of arbitration agreements. We have been dealing with the main components of arbitration clauses, and we have also discussed a checklist incorporating the main terms. Just to clarify, by main components or main terms, we mean those terms that are essential for a valid or an effective arbitration agreement. For example, even if you do not choose a place of arbitration in your arbitration clause, the clause is nevertheless valid because an arbitral tribunal constituted under the arbitration clause could determine the place of arbitration. But if the other party does not act on a request for arbitration, and if there is no appointing authority chosen, it would be difficult to get even the arbitral tribunal constituted, especially if the transaction is international. And you would be faced with a party who will be ready to take up guerrilla tactics. In this lecture, we will look at some of the other components of arbitration clauses that commonly form a part of a typical arbitration clause. Now, once again, let us go back to the unsettled arbitration rules, like what we have been doing in the past few lectures. In the unsettled arbitration rules, you would have noticed that the model clause itself suggests that the appointing authority, the number of arbitrators, and the language of arbitration are to be added. Accordingly, the rules state, note, party should consider adding A. The appointing authority shall be, B. The number of arbitrators shall be, D. The language to be used in the arbitration proceeding shall be. We have already seen about the place of arbitration in one of the previous lectures. Now, about the importance of choosing the number of arbitrators. Frequently, parties are faced with the problem of choosing between 1 and 3 arbitrators. This choice is important because it does not make sense to appoint a 3-member arbitral tribunal to decide a dispute of trivial value. It is also difficult to get the time for hearings from the 3 arbitrators who are usually busy people. So, the recent trend is to appoint sole arbitrators. The thumb rule is that in case the agreement is of high stakes, parties tend to provide for 3-member tribunals, while if it is not huge, 1 arbitrator will suffice. There is an increasing trend to choose a sole arbitrator. Now, let us discuss about the appointing authority. Designating an appointing authority becomes important in ad hoc arbitrations. If you do not designate the appointing authority, you may have to go to court at the seat of arbitration to get the tribunal constituted, if the other party does not agree to your choice. In arbitration, time may be of the essence, and in case you do not get the tribunal constituted in time, you may lose the strategic advantage. So, it is important to get the tribunal constituted quickly. Designating an appointing authority has important consequences on the strategic aspects of the arbitration. But how will you do that? If you have chosen the unsettled arbitration rules, simply repeat what is stated in the model clause. And the clause reads, A. The appointing authority shall be so and so. It could be a person who would be an appointing authority or even an institution. Like for example, in Indian road related contracts, the Indian Road Congress is often designated as the appointing authority. Or it could be the Permanent Court of Arbitration. Or it could even be an official such as, say, the Secretary General of United Nations or Secretary General of the Permanent Court of Arbitration, and so on and so forth. But there is one thing that you must note before choosing an appointing authority. The appointing authority or a person or even an office must be ready to appoint the arbitrator. It wouldn't make sense, for example, to say that the President of the United States shall be the appointing authority when the President of the United States might not even be engaged in that activity of appointing arbitrators. If you have not chosen unsettled rules for your ad hoc arbitration, you could simply state, in case of failure by the parties to agree on the arbitrator, so and so shall be the appointing authority. Or alternatively, you could simply state, in case of failure by the parties to agree on the arbitrator, dash shall appoint the arbitrator. Note that these clauses that we discussed just now are for a sole arbitrator. If the parties decide to go for a three-member tribunal, each party generally appoints an arbitrator, and the two arbitrators so appointed appoint the third arbitrator. They generally do so, but there could be a situation where they are not able to agree on the presiding arbitrators. To address this situation, you may state in the arbitration clause, in case of failure to agree on the presiding arbitrator, dash shall appoint the presiding arbitrator. And you could fill up the appropriate appointing authority that you and the counterparty may agree. Now, coming to the language of arbitration, it is important that you designate the language of arbitration, especially when it relates to international arbitration. Not many people are aware of this, but this is important. Just imagine a multi-million dollar claim being arbitrated between, say, an English and an Egyptian party, where the language of arbitration is Arabic. Most of the technical documentation, which are in English, may have to be translated to Arabic, and this would cost a huge amount of money. Imagine there are close to about 10,000 pages worth documents, and in English, and it may take even say 5 dirham per page. And if you consider that, then look at the total cost involved. Crucially, many laws and arbitration rules do not provide for a default choice of language. See, for instance, the unsettled model law and the unsettled arbitration rules. But usually, international contracts contain a clause designating the language of the contract. This usually becomes the language of the arbitration. But if you do not want to designate a choice of language clause in your contract, you could nevertheless have one for the arbitration agreement. Notice the phrase used in model clause of unsettled arbitration rules, which reads, D. The language to be used in the arbitral proceeding shall be so and so. If you ask me, I would prefer the simpler version of the choice of language clause as is available in the model clause of SIAC rules. It simply says the language of the arbitration shall be so and so. Now we will update the checklist that we created in the last lecture. Notice here that serial numbers 4, 6 and 10 are additions in the checklist pursuant to the discussions in this lecture. Serial number 4 says how many arbitrators should constitute the arbitral tribunal, 1 or 3. Note that it is possible for parties to appoint even a 5-member arbitral tribunal. But that could depend on the number of parties involved and in case of very, very large arbitration. But 5-member tribunals are extremely rare. Serial number 6 says whether there should be an appointing authority in case the appointment process agreed upon by the parties fail. This is applicable only in respect of ad hoc arbitrations, as in case of institutional arbitration, the institution itself functions as the appointing authority. Serial number 10 says whether the contract provides for a choice of language clause. If not, what would be the language of the arbitration? So more on drafting arbitration clauses and updating this checklist in the next lecture. Hasta mañana.